Hi, everyone, and thank you for joining us for today's webinar on ratings, tips, and tools. Before we get to introductions, I'd like to make a few housekeeping announcements. This webinar is approved for MCLE credit. In order to qualify for the credit, you'll need to stay logged in for the entire session. Hopefully, we'll have time to answer many of your questions. If you have any questions, please click on the Q&A bubble on the bottom of your screen and type them there. My name's John Blake, and I'm the Director of Sales here at Gemini Legal. We're always striving to bring new and valuable content to the applicant workers' compensation community in California. You'll be able to find a recording of this and prior webinars on our Gemini Legal YouTube channel. You'll also find attorney interviews and other helpful information there. I'm thrilled to be joined on my panel today by three very knowledgeable panelists that will each share some unique perspectives that I think we can all benefit from. I'll let each of them introduce themselves, starting with Judge Hawthorne.
Hi, good afternoon, everybody. I am Judge Hawthorne. First and foremost, I need to let everybody know that the materials and opinions expressed during this presentation are my own and do not represent the position of the DIR, the DWC, the WCAB, or any judge within the DIR or DWC. It is not intended to be used as legal advice, and each case or circumstance is unique. The outcome of every case is dependent on its own set of facts. With that being said, I am Judge Hawthorne. I am here in San Diego's WCAB. I have been here since 2018 and a judge since 2015. And as you all know, I'm always accessible for questions and answers and always willing to do informals with everybody as well. So thank you for coming.
Thank you, Judge. I appreciate it. And Andrew, why don't you go next?
Hello, I'm Andrew Lockard. I'm an applicant attorney down here in San Diego. I also have a splash of employment and labor in my practice, primarily focused on ADA and FEHA issues with the interactive process that, as we all know, often interact with our workers' compensation cases. I think that's all you need to know from me.
Great. And Brent?
Hello, everybody. I'm Brent Sheperd. I am the ratings consultant at Gemini. I have been doing ratings for 16 years now, so thousands and thousands of cases. I've worked for firms, I've worked for other companies, so I've seen both sides of the coin, and yeah, I've been doing this for a very long time.
Good deal. Well, with that, why don't we just go ahead and get right into it? So this is a huge area to cover, especially in a 1-hour webinar, but how about we walk through the life cycle of a case to talk about where ratings come in? Judge Hawthorne, you want to start on that?
Thank you so much, Mr. Blake. Yes, what I'm going to do is just briefly go through how do we get to a workers' compensation, and then at the end is the rating. And I think people sometimes forget that. And the reason why we wanted to do a brief overview of how a case moves through the system is because there's some differences that we see, especially on the bench here, from the beginning of a case to the end of the case. One of the first things that came to our attention when prepping for today's meeting is that at the beginning of a case, when the applicant does the original form, which starts a case, is the DWC-1 form. And the reason why I wanted to bring that to the attention of everybody is because that's a critical form in which the applicant has indicated the body parts that were injured. So that starts the case, right? Applicant says, I'm injured. The DWC form gets filled out, moves along to the insurance company to have their days to review them to see if they're going to accept or deny the cases. And remember, at that point, it's also critical when we're looking at a case is if it's an accepted case or a denied case. And if it's an accepted case, what's critical when it comes to a rating is the nature and extent of the injury that has been accepted. One of the reasons why we wanted to point that out today is because at the end of the case, after we've now gone through our treatment, and at some point, whether it be a panel QME or primary treating physician who is done treating the applicant and they've hit their maximum medical improvement or permanent and stationary status, they issue those reports, which we then move on to be rated. The reason why I wanted to point this out as through the process of the case is because it's really important, especially on the applicant side, to remind yourselves to go back to that original form that started the case to ensure that all body parts indicated on that DWC-1 are addressed and finalized before we get a proper permanent disability rating. Whether or not an injury or I'm sorry, a disability has occurred is important, because when we're looking at different body parts and we're looking at the final reports to rate, just remember that it doesn't help to rate one part of a report if we have other body parts that have not plateaued or you don't have an MMI report. And I bring this up because different body parts rate differently. We have to ensure that we're compensating individual injured workers appropriately for their final level of disability. And that's all body parts. Don't assume just because it's no longer addressed in a medical report that it doesn't have permanent disability or that it shouldn't be addressed. Judges are the ones that indicate in their findings and awards, or when reviewing your guys' submitted settlement documents, are we relying on substantial medical evidence? And it's important to remember from the beginning of the case to the end of the case, when they've plateaued, that all body parts are addressed. And therefore, whether or not the medical report is substantial will let us know that all body parts on the DWC. With that being said, it's also very helpful when we get to that part in a rating and you're submitting settlement documents that you submit the DWC-1, because I will tell you, if you're getting into fights with either the defendants and you've indicated on your DWC-1 that the left foot is injured, and now I only have a report indicating that the left knee has permanent disability, without submitting all the proper documentation for judges to review for finality, we cannot assist in assuring that substantial medical evidence exists in which a rating has been based upon. So with the life cycle of a case, when you have that DWC-1 to the original when they first go out for their first evaluation, whether it be with the Concentra or any other clinic, to the final reporting of an MMI, it is helpful to remind yourself to review all of those documentations in the middle of what body parts have been treated and what body parts are still denied, to ensure that everything is comprehensive at the end of a case for a proper and full rating. I think that's the end of that section.
Thank you, Judge. So, Brent, there's a few things that applicant attorneys need to consider when doing ratings. One of them is the difference between apportionment and causation. And I know that you can cover that part of it.
Well, yeah, I do read a lot of reports, and this mostly applies to cases where you have multiple claims. When you have a case with multiple claims, sometimes you might have a continuous trauma claim, specific dates of injury. Sometimes there's 2, there can be 3, there can be 2 CTs. Causation and apportionment play a huge factor in this, and you have to really pay attention to the two and know the difference. Obviously, apportionment more applies to non-industrial factors, and causation would help more with deciding which, especially in a case with multiple body parts and multiple injuries, which body part is caused by a single injury or a continuous trauma injury claim. And most attorneys think that if you start to parcel out the body parts, that it's going to lower the award because you're separating the body parts into different claims, but that's not always the case. Sometimes it actually benefits the case. So you have to really pay attention to those parts. Sometimes the examiners don't always get it right. Sometimes they don't have all the information. Do not be afraid to request supplemental reports for clarification. The more clear the case is, the more sound and the better claim you're going to have.
Another question, are the practitioners and examiners limited to the 4 corners of the AMA guides?
They call them corners, not walls. So yes, the AMA guides definitely has corners that you want to abide by as an examiner. However, as we all know, there's always ways around the law. There's always new laws, there's always new cases. So especially cases like Alvarez-Guzman, rating by analogy. The main thing that you want to get out of every case is you want to have the fundamental amount calculated so that you actually get the true disability instead of sometimes always staying in the 4 corners, especially when it comes to chapters 15 through 17. You will see a lot of unaccountability for certain impairments and dysfunctions and diseases. So they're just corners. They can step outside them. Again, the examiner's word is really gold in a case. Of course, each side has something to prove, but you definitely want to be aware that they're corners, they're not walls.
With that being said, one of the things that we did discuss yesterday is what's really important to look at the AMA guides. Brent is correct in that we want to focus also on chapter 15 through 17 because a lot of people forget to read those. But all of us agreed yesterday that one of the most important things about the AMA guides is read the first 10 pages. There's significant amount of material in those first 10 pages, which will also address of whether or not you're limited within those four corners. And don't forget that the AMA guides were not written literally for a workers' compensation system to evaluate permanent disability. That wasn't what its goal was. We adopted it without them recognizing that that's what we were going to do. So what are your limitations? Your limitations are whatever you put on yourself or the constraints that you're putting on yourselves. The AMA guides don't necessarily address all the disabilities that may come forth. They just basically address the basic ones that we see, and so we can rely on them. But it's not a full, complete book of what everything could go wrong. I mean, just as much as we have difficulties finding the appropriate specialists and doctors in our community, the AMA guides is limited to its four corners as well. But that's the book's problem, not yours.
Go ahead.
Sorry, John. I made the mistake early in my practice of not reading the first two chapters of the guides, which frankly are the most important because the guides always appeared very cryptic to me until you read the first two and you appreciate that they concede this is far from perfect, but here's how we arrive at what we're doing here. So I think it's always crucial to keep that in mind, that the guides are imperfect, but they do give you some key information in the first two chapters as to how they should be used.
Yep. And, since we're on the subject of the AMA guides, I know it's fundamental for applicants' attorneys to know what's in the AMA guides, but Brent, are there some other interesting points that attorneys should pay attention to?
Definitely. If you're going to be rating cases, there's some tools that you need to have. It's not just the AMA guides. You need the AMA guides for sure. A deep understanding of the AMA guides is going to help you really get the best out of each case and get the best for your applicant's true disability. You're going to need the schedule, know that schedule front and back. That is what you would use to take what an examiner assigns and apply the California law to it. That's where all your adjustments are. That's where you're going to find all the group occupations. A good tool for finding group occupations would be using the DOT. Sometimes, most occupations are generally understandable, but there are some interesting ones that can be harder to confine to one group. With the DOT, with the schedule, you should be able to, but again, and don't always think that the higher occupation number is going to get you the highest rating. Now, generally speaking, if you're in a 200 group versus a 400 group, the 400 group will most of the time give you a higher rating. But if let's say you have two different occupations in a 300 group and they're not that far from each other, depending on the type of injury and the type of body parts that are used in the case, the lower one actually sometimes will give you a higher value. So keep your mind open when it comes to occupations. Don't just jump to laborer. That's what I get most of the time, laborer. There's so many different kinds of laborers. So you have to really, really pinpoint what the exact occupation is, what the applicant was actually physically doing every day, how they were injured. That all can really change a case. You definitely want to have the labor code book with you because the guides and the schedule only cover so much. There is a lot in labor code that changes how each case is going to be. Don't be afraid to do case research as well, because even though cases are specific, don't generalize every case. Because if you generalize every case just based off the guides, based off the schedule, you're missing out on a whole opportunity. And don't be afraid to do your case research because there are many, many cases that have passed that have set precedences. So definitely do your case research. With those 4 tools, you can't fail.
Let me expand on that because I know that sometimes we talk cryptically. When he's saying the schedule, he's meaning the PDRS. So don't forget that. Okay. And that's one of the things. And then one of the things, and the reason why this is important, and Brent brings it up, and I have to bring it up as a judge to you guys, is that understand that we have a liberal construction of the labor code, correct? So that if you are looking at different, don't be pinholed and saying, okay, my guy was delivering flowers and therefore he's a delivery driver and there's this body part or this chapter that I can look at. Remember that it's imperative that you take the opportunity to try to rate your cases multiple ways, because the highest rating is the one that you're going to advocate for and most likely get, because that's what the labor code tells us to do. And as a judge, we have to follow what the labor code's telling us to do, unless and until we're told differently. So the highest rating is the one that you're going to get and the one you need to advocate for your client. And it is correct that when you are looking at different job descriptions or different job duties, find that one that fits. And remember the case laws that tell you that. What was your applicant doing at the time of injury? Was it within their scope of employment and what their job description really was? Or at that time, were they acting in a capacity different than what their regular job was? And do you get that code? Do you get that occupational group number, which is going to rate higher? Just remember those things, and remember that you get the highest one. Okay. That was one of the other things that we were going to talk about, was the, the liberal construction. And it does impact your permanent disability rating. And remember that, every single, it's a string, right? Your rating is a string. You have the body parts. And so you need to remember that. And when we're talking about that, also look at the way that the different body parts, and are they being applied correctly? For example, and Brent's even better at this than me, range of motion versus DRE. Which is the appropriate way to rate it, and how do I work it so that it is the best way to rate it for me? Is there something in the description, or is there something in the code, or is there something in the AMA guides that tell me I could go to this table, but does Alvarez-Guzman really apply, and that I should be looking at this table and looking over here? Is this the occupational group number, or is this incorrect? And I will tell you, as a judge on cases, they're rare, but I do have cases where actually the occupational group number is something that is at issue. And I will literally go back into the labor code, because the labor code has a section in it that actually describes different duties within that group. And so that I can pick and see which group number is the best and most appropriate for what the job description was when you guys are disputing it. And for the oldies but goodies that are still around, I still find the RU91, the old job description that we used to use for voc rehab, actually quite helpful, because it lets me know where you guys are differentiating on what the job description is that you think you're having. I have no idea why it's going in and out. Welcome to the state computers. What can you go? Anyway. So that's just something else that I wanted to point out, because still, no matter what, even though there's been tons of changes in the laws, even, from SB 899 before and after that, liberal construction and the benefit to the applicant is still the most important thing. It's a benefits administering system. So we have to administer them accordingly and correctly, which is to the most beneficial to the applicant. That's not, and it hasn't and will not probably ever go away.
I'd say about 90% of the time, if there's a dispute between myself and the defendants about rating, it is about occupational variant.
Usually.
And like you were saying, you have the benefit of liberal construction, right? So if someone has a CT injury, for example, and they're doing all sorts of job duties, right? Which one's going to best fit the situation? But what I always do when I'm rating too is, if I'm looking at the occupational variance, I'll look at the other jobs that are in the same neighborhood, right? That is, say, 300 versus 310 or whatever the case is. You can see which occupational variant it's going to generate for nearby occupations. And sometimes that can help you kind of tip the scales in your favor if you can string together why that other occupational variant is going to be better.
Makes sense. All right, good deal. So we brought up Alvarez-Guzman a couple of times. Of course, it's one of the most significant cases regarding permanent disability. What are some of the key points for applicant attorneys to keep in mind? Would you take this one, Andrew?
Of course. Yeah. So Alvarez-Guzman's about 13 years old now. The nutshell version of it, because frankly, it could take up a whole presentation in of itself. A scheduled rating is going to be rebuttable, excuse me. Obviously, the party that's going to be disputing the rating has the burden of proving that. Now, we have to keep in mind, though, is functionally Labor Code 4660, if you're using the scheduled rating, that presents prima facie evidence of what the appropriate PD rating is, right? But what Alvarez-Guzman allows us to do is to rebut that within the four corners of the guides. Now, something interesting I saw is that Alvarez-Guzman 3 permits extrinsic resources. Alvarez-Guzman 2 does not. And I was thinking about that, and that makes a lot of sense. If you consider that the guides now are 20 plus years old, medicine's changed a lot during that time, right? Our understanding of anatomy in the body has changed a lot. So using an extrinsic resource to inform where else you might go within the four corners of the guidelines makes a lot of sense. And this is something that you see often with CRPS, for example, is that our understanding of that condition has drastically changed, right? And using extrinsic resources to figure out what is going to best and most accurately capture the applicant's disability could be through an extrinsic resource.
And on top of that, someone did ask the question, why haven't we updated which AMA guides to use?
I was just gonna go, yeah.
I don't know. We don't know why it hasn't. And when you think about it, right, how critical is that going to be when we have, I mean, COVID long is not in the AMA guides, right? So I don't know why they haven't updated it. We haven't even gone to DSM-V5, I think. I mean, we're stuck with what we have. And it's not uncommon for law to be very far behind science. I also can tell you, I have not heard anything, even in judges training at all, about updating that or using anything else. Well, actually I am the legislative branch, but technically kind of maybe sort of judicial branch of our government. And so my statement to that of why haven't we updated it? You got to ask the legislators and go there. And I highly recommend it because I think that the AMA guides have realized that we use that sort of system. And so maybe the next generation will actually be able to appropriately address some of the issues that have come forth since the last time we did that, the AMA or use the AMA guides. But I don't know why. I don't see it changing in a while. And I think it's available. We just haven't adopted it. So sorry about that.
I think the answer to the question of why haven't we changed it is a political one.
Yes.
I don't know if you can say that from where you're standing, but there are benefits to using the 5th edition of the guides versus the 6th edition of the guides. And there would be a series of consequences, especially regarding permanent disability, if we were to incorporate the 6th rather than the 5th.
Okay. So there's another question here. It says, how do we learn how to do the ratings? Is there a class on this? And I know Cobb gives a number of classes. They actually have a seminar in Monterey that I have attended the last couple of years. It just passed a couple months ago. That's an excellent session on how to do ratings. Any other suggestions?
Is the one in Hawaii, Andrew, with Cobb for rating as well? Is that the Hawaii one or is that a different?
Yeah, so the Hawaii one this year, the topics at Hawaii have changed a little bit from year to year. It used to be almost exclusively about SIF, but this year it's going to be about permanent disability rating specifically. So thank you for bringing that up.
Also, there are some local, like when oh God, I'm going to date myself. I was sent to a class and it was given by Don Pilger. And that was one of the first things becoming an applicant attorney that was kind of mandatory for me to learn was the rating itself. So that's always, there are other classes locally, and I think it was through CTE or something like that, but it was a vocational school that actually taught it. So, but I highly recommend you do. But as an aside, right, if you're not sure or you need at least a basic starting point, don't forget that we have the DEU and you can always submit it to be rated. And sometimes that's either just as your backup or your secondary. They're really good. They've been doing them for years, but they're not always 100%. And in addition, I mean, I'm sort of jumping out of order here, but sometimes our raters are limited in what, if it's a formal rating, then it's an instruction given by the judge and then they're stuck with that and they can't be creative. But a lot of times, for example, especially on in pro per cases, which no one cares about here, but I do, but I will send it to the DEU before I will approve a settlement because I want to make sure that it's based on something that is correct. And it's not uncommon for the DEU to come back to me and have said, Judge, I can't rate this. It's not correct. That's not the the doctor hasn't addressed this body part, or the doctor was using DRE and it should have been range of motion, I feel, or the doctor is talking about the left ankle, but I don't see any impairment given on that. So while it's imperative that you guys do learn the ratings, because it gives you a basis of a starting point, at least where to start negotiating even on a resolution of your claims, just remember that it's always a good idea or helpful, even if you get the DEU, because at least it can let you know, wow, I was totally off, or yes, I got it right. Let me tell you that, yes, I got it right, even feels good for me sometimes, because I don't know always. Yeah, there are classes and there are resources out there, and I highly recommend you do them, especially before you send out your first demand letter.
The original instructions are in the schedule. They do go step by step. It is a little bit of a difficult read the first time. It's not that easy, but every instruction is pretty much in there, just at least how to develop a string and what you're pulling from. Again, it is a very old schedule. So when laws change, like in 2013, the modifier, that's not in the schedule. So you do have to be up to date with current laws, because again, the schedule was created in 2005 and it has not changed really since then. So there are things you would need to know on top of the schedule, but the basics are in the schedule. But Judge Hawthorne is correct. It is very helpful to take a class.
Yes, and whoever mentioned that IE, I think that's who I took it from, the Insurance Education Association. Yeah, I think that's where I got sent 23 years ago. So.
Great, thank you. And thank you, Eamon, for typing in. Med Legal used to have a book that taught them, and there's calculators. So if you don't have access to our calculators, reach out, we'll get you access. So they can be helpful, but thank you for pointing that out. All right, so let's go ahead and move on. So use of vocational evidence to establish permanent disability has evolved through case law. What do applicant and attorneys need to remember? And Andrew, why don't you start on this one?
Of course. So Ogilvy, what's interesting about Ogilvy is that it presents actually 3 different ways to rebut a scheduled rating. Your Honor, I don't know if you've seen some of the other 2. But I think the most commonly used one is the LaBeouf method, far and away, which, and I'll read you the quote. You can use it to rebut when the injury to the employee impairs his or her rehabilitation. For that reason, the employee's diminished future earning capacity is greater than reflected in the employee's scheduled rating. And that would obviously be through vocational evidence. But that then raises the question of what vocational evidence is appropriate to use. Many cases downstream from there, Dahl obviously being one of them. Dahl has something of an ugly passage in it. Dahl explicitly says they're not determining the issue, but says in dicta that vocational evidence cannot be used to establish partial total disability, permanent partial disability. Again, it says that in dicta. I don't know why it would go out of its way to make that statement in the case. But I think the bigger takeaway from Dahl is that the type of vocational evidence that was being presented was explicitly rejected. That is to say, it was an assessment of a theoretical group of similarly situated employees versus an individualized assessment of the injured worker. And you do have to keep in mind LaBeouf as well, that there can be apportionment to non-industrial factors, such as general economic conditions, illiteracy, proficiency in speaking English, or lack of education. Fitzpatrick, too, I think is an interesting case similar to this. Fitzpatrick, I find puzzling in many ways, especially when it comes to statutory construction, because 4662 B, subsection B states all other issues of permanent total disability are established in accordance with the facts. Now, to me, that's a very plain, simple, easy to understand language in accordance with the facts. However, Fitzpatrick takes the position that what that really means is that you're going back to 4660, right, which is the prima facie evidence of disability established by the permanent disability rating schedule. So that said, 4662 really means 4660. Why that's the case? Well, you can read Fitzpatrick and see if you can come up with a better answer than myself. Something else to keep in mind, and I do think this is really interesting, that there are several cases now supporting that medical evidence alone can be used to establish permanent total disability by opining on their ability to compete in the open labor market. There was a case out of our board, the Brown case, which is writ denied, that had no vocational evidence, but nonetheless rebutted the schedule using only the medical evidence that they were permanently totally disabled, which I think is interesting. Now, a lot of cases will also tell you that you normally want to rely on both vocational and medical evidence when rebutting the schedule. A judge is obviously not permitted to use their own judgment in establishing, no, I think this is the correct disability to arrive at. You need to present substantial medical evidence both for vocational and medical.
And with that being said, since we're crossing over also, and it's just reminding me of a case that I had with regards to that. When we're talking about apportionment, and we're looking also at vocational rehabilitation, and we're looking at permanent disability, and when we're applying apportionment, just remember that this is something that I've seen practitioners forget, but the attorney on the one case did a great job, which is remembering that, let's say you have an injured worker who then goes through certain medical treatments, and that medical treatment goes awry, and now that individual could be more disabled or even 100% disabled just based on the medical procedure that was performed during the course and scope of the underlying case. There's no apportionment in that additional medical treatment. There is nothing that can be apportioned away from that, you know. So just remember that. Remember, where is your permanent disability coming from, or how are you arriving at permanent disability? And that also, you know, remember that when you're looking at the change in the rating schedules that have to do with sexual function and sleep disorders, right? Like you won't get that unless certain scenarios are met. What, you know, is it a compensable consequence? You know, on a psych claim, is this was this an incident, you know, sort of like the guy with the gun walks into the 7-Eleven and now you have a psych claim. Okay, that would be one that we would allow psych. So just remember that. Where are we arriving the permanent disability that we're rating from? Is it coming from the original injury? Is it a compensable consequence? Is it coming from the medical treatment that arose out of the underlying claim of itself? And I have seen it where, let's say there is an issue with the medical treatment and now there's no apportionment, but that medical treatment that they did have from the original underlying case, right? And then we're looking at, I forgot where I was going with that, but I was going to talk about that disability in itself, and do we add that, and looking at other cases of how we're arriving at a final level of permanent disability. But I think we're moving towards other cases, which we'll let Andrew go along with that.
No, I think I covered the ones I wanted to discuss, but no, you raise an interesting point, because there's I think you could take the case law a couple of different directions here. So for example, something that I've had come up a lot is that someone has impairment in their spine. It is fused, right? And that's on an industrial basis. So that impairment, in my opinion, because they put in, you know, the metal brackets and whatnot, the spine actually fuses together, the vertebra fuses together. Yet after that procedure, the doctor will still apportion to pre-existing pathology in the spine. In my mind, I'm thinking that pathology is literally no longer in the body, right? That disability, that impairment is no longer there. The existing impairment is completely due to that spinal fusion, right? And I've had doctors disagree with me or fail to understand my argument on several occasions. And then there's case law that suggests that perhaps if there is disability due to industrial treatment, that there need be a worsening of the underlying condition due to the industrial treatment versus otherwise. So there's a couple different interpretations out there, but I think that's always ripe for a doctor deposition if you're going to attack apportionment in that way.
And I know that Mr. Blake said he likes stories, and I know that George Chinchilla's on this line, and he'll remember Judge Blass over in Santa Ana. We used to have this huge discussion about a knee replacement, right? So now the knee is completely replaced. So is there disability? It's a brand new knee, right? So if you've replaced it all, how is there any disability? Or and you can go with that with hips and knees or whatever. So make sure you're looking at that and looking at it appropriately. And let's say you get this total knee replacement, right? And now they want to do apportionment. To what? You have a brand new knee. What can you apportion? It's all fixed. So if there's a disability, how is that in coordination with anything that was non-industrial or even just, that was pre-existing beforehand, because you fixed it all. So those are just some interesting, and I think he even did a decision on that. I don't remember if Mr. Chinchilla will remember that as well. So that's just another one. And then going along those lines, then we do want Brent to also discuss kite and combining versus addition on these disabilities, and how does that play out when you're looking at them, Brent, when you're rating these cases?
I would say probably the number one common mistakes that I find is the issue of combining and adding, because, and again, this is mostly in the chapters 15 through 17, the spine, especially if you're doing the range of motion method, upper and lower extremities. There's many body parts. There's many different types of impairments. The shoulder alone has several different kinds of impairments. And a lot of examiners, you have to remember too, examiners are calculating WPI. They're not calculating PD. That's what the schedule does. So a lot of examiners do make many mistakes when it comes to combining versus adding. Aside from cases like Kate, the general rule of thumb is you're always combining. Even if it's in the same body part, the same shoulder, if you have two different impairments, they're combined, they're not added. Generally speaking, the only time you're going to be adding is within a range of motion method. If you have several different upper extremity impairments for range of motion, those are added at the upper extremity level, then converted to WPI. I see a lot of ratings where there'll be two strings for a right shoulder. That is not how it works. There's one string per body part. Even if you have multiple impairments on that body part, there's only one string. And it's very strange to me when I see that, because that is very incorrect. When it comes to kite, you have to be very careful of the terminology that the examiner used when discussing kite and synergistic effect. Sometimes they'll just blanket statement apply kite to the whole case, including all body parts. But to have a really strong case, you want the examiner to clarify, where is the synergistic effect? Is it between the elbow and the shoulder? Is it between two different body parts? Is it between the entire orthopedic evaluation that kite is applied to in regards to an internal side? There's different ways that it can be applied. So you really want to pay attention to the vocabulary used by the examiner. That makes a huge difference. I've had cases where kite has been applied and it goes from a 50% case to 100% case like that.
That is correct. Yeah, and you have to make sure that there, again, a judge can only make a determination on substantial medical evidence. And remember, the judge makes the determination on the substantial medical evidence. Don't list it as an issue on your pretrial conference statement, please. We can only do that. There was one thing that I do want to circle back. I think someone also commented on this, but Brent had mentioned it before about reading the labor codes and reading the sections and making sure you correctly apply them. We have been doing a general discussion here with regards to ratings and regards to apportionment, but remember who your clientele is. Remember that there are certain classifications of employees that, like police officers, firefighters, and everything, and they get certain presumptions. And don't forget that when you're rating them. Okay. And don't forget that when you're looking at what would be the highest or potential ratings. And with that also being said, I know this is a rating seminar, but one of the things that I do see most recently that is going to come up, especially with long COVID cases, or else when we're looking at firefighters, cancer cases, or any of that stuff, is also understanding are these diseases that are something that are going to be lasting around for, I'm forgetting the word right now, but what are going to be lasting for a long time, that we're going to maintain jurisdiction over for a long time, because they're, you get cancer and then what happens to it later on. Why am I losing the word of what I'm looking for? So frustrating right now. But whatever it is, it's because we're going to maintain jurisdiction over something that the disease is. Someone's going to put it in the.
I'm glad it's you,
And
because
it's-
it's usually me.
It's an insidious progressive condition.
As soon as you start, it's an insidious progressive disease. Just remember that, right? Because when we're looking at, although we're doing ratings now, right, and we're talking about ratings, and that if you look at the labor code and you do a new and further, or you get another injury to the same body parts, and you automatically get that apportionment to a prior award or anything, if you do something have like an insidious disease, and then we're looking later on, the person's gotten significantly worse, at least you know that the compensation could be appropriate during those things. But just remember that. Remember who your clientele is. Remember the non-attribution clauses that apply to these our first responders. So just remember that when you're doing ratings. Don't forget that. Look at the labor code and what can apply to you, positive and negative, just so you know what you're getting yourself into.
And Judge, you mentioned a pre-trial conference statement. There were some common mistakes that you wanted to bring up about pre-trial conference statements, and I wanted to.
Yeah, and Andrew and I were looking at it yesterday, and it was pretty funny. So on every pre-trial conference statement, just for the judge, and don't look at us like we're crazy when we ask you for it. When you're filling out a pre-trial conference statement, the reason why it's so important for you to understand a rating and getting it correctly is because literally the pre-trial conference statement tells you that you must give us your proposed ratings. And if you're looking at me or you're looking at the screen right now and going, what the heck are you talking about? Look at the first page, right next to where it says pretrial conference statement. It lists a labor code, 5502D. Guess what that labor code says? You must give us your proposed ratings. So although there's no baseball arbitration anymore, Smitter's not on the bench anymore, you still have to give us your proposed ratings, okay? And the code tells you to do so. So that's why it's great that you guys are here and learning how to rate and what you need to do to get accurate ratings, because we're going to ask for them. I have a right to it and I need it. And it's compliant with the labor code, which is what you got to do. Some people are also making comments about how can kite be valid if there's no medical research to support synergistic effect, to support the diagnosis. I understand that. You're right. How can kite be valid? Well, that's where you need to take these cases up and get finalized opinions on them. Because I will say that some of the cases that we're talking about now, some of them are not writ denied. Some of them are just board decisions. Some of them are not binding on us. And remember, don't cite cases that are not binding unless you're going to give us that disclaimer of, although this is not binding on the court, I do find it persuasive, Your Honor. My case is more like this than that. So, and you're right, there are thresholds that have to be met in order to apply certain cases. And that's why we talk about are these inextricably intertwined such that we can't break them out, right? You know, if you're looking at a Benson issue, I've got two cases, they became permanent stationary at the same time. Now, this is why it's important to learn how to rate, because make sure you're on the correct side of the argument. Sometimes arguing that Benson applies because now I'm going to get two different steps at two different rates would be a much more beneficial outcome for your client versus arguing the other side where Benson doesn't apply in this case, Your Honor. And this is why, because they're inextricably intertwined, or we can't break them up. You know, that's it. We can't do it. So that's why it's important to know your ratings, because you need to know which side you want to be on, either on Benson or some of the other cases that apply as well. Remember, when you're talking about apportionment, the reason why I want to come back to this again is we know your burden of proof, know who has the burden of proof. It is not uncommon to see someone fighting on one side where I want to look at them and go, why are you bringing it up? It's not your burden. Don't worry about that. You know, don't, you know, if a doctor, I've literally had new attorneys who tell me, well, it's not substantial medical evidence, Your Honor, because apportionment hasn't been addressed. Applicant attorney, don't say that, because it wasn't your burden in the first place, but thanks for pointing that out. You know, like now I do have to go, you know what I mean? So make sure you know which side you're on, make sure that you know where you're going to end up when you're done with your argument. And that's why it's really important with the ratings.
So a question came in, as a legal matter under 5502D, are parties required to exchange their full rating strings prior to an MSC? Or does sending only the total PD rating suffice?
You're both filling out the pretrial conference statement. Yes, I know we have fights and people don't necessarily do their side, but there's nothing to hide. I mean,
Mhm.
it is what it is. And, playing the game of, well, I want to see yours first. It doesn't matter. I don't care. I mean, the judges don't care. It's not because, well, one side's going to come up or one side. I understand for you guys, sometimes you might not want to disclose that because of, let's say you rated it. And by the way, the defendants actually rated it higher and you're like, shoot, now I've rated it lower. It doesn't matter. The judge still is going to have to correctly rate it. And we're not bound by what you submit as your final rating. We can conform to the evidence, which judges do a lot of the times. I mean, I literally have cases on TTD rate, and everybody proposes to me what they think the TTD rate, and I was like, that's fine, but my math is completely different than yours, and I'm going to conform to the evidence because I have the wage statement, and I have her W-2s or whatever it may be, and so I'm going to find it the right way. So it's not necessarily detrimental. If you're already going to trial, you couldn't resolve it anyway. So what's the difference if you give me the ratings? You shouldn't be in front of me if you could agree anyway.
Yeah, and don't worry too much about opposing counsel's rating not matching yours. Very rarely do they exactly match. Very rarely. Many factors involved, and don't be afraid of not matching or undershooting a rating. Like the judge said, the truth then eventually comes out either way. So there's nothing really to hide.
Where should the rating strings go? Probably underneath issues, or on even that's fine. You could put it underneath the issues page.
Yeah, I think it makes sense that if that's how you find out when you're filling out the 5-pager, sometimes whether or not it's a stip or an issue. Right? You may be in agreement and didn't know it, in which case then it's a stip.
Exactly. And then why am I going to trial? Because you're already agreeing on the permanent.
I have a couple of those trials anyway.
Nice. All right, so we want to move on a little bit here and see if we can finish with some discussion on some pivotal cases while we still have a little bit of time, and what applicant attorneys should always remember from these cases. So the first one was Benson. So who wants to tackle that?
I think we discussed it a little bit, which has to do with the reason why we brought up Benson and we were talking about it when we were preparing for today is that idea of making sure that when you're rating something out, which is the most beneficial to the applicant, if you have two different steps, right? Because two different body parts wind up becoming permanent and stationary at the same time, and then we wind up rating them. Or what's most beneficial? Two separate ratings at 38%. Is that rating or monetary value higher than not applying Benson? So just again, with Benson, it's what side you're on. Someone also wrote a question about COLA, the cost of living adjustment. Then you're talking about commutations and you're talking about, the permanent disability levels. COLA is not necessarily, and Brent, correct me if I'm wrong, but COLA doesn't necessarily have to do with the rating itself as much as the monetary value and what's the applicant going to get afterwards and when does COLA kick in. That's I highly recommend you're going to reach out to the DEUs and get your commutations on those issues. They will always know, and if they don't, or if the DEU has a question about when the COLA kicks in, they will bring the hypotheticals to us judges and ask us, so hypothetically, judge, if this is, and we'll say, okay, it's start here or whenever it may be.
You only have to worry about COLA if you're going to have a life pension calculation, because COLA is a future calculation. Permanent disability is in the moment. So you won't really find that you find that only in the really higher cases that have a life pension award.
Correct. And then you're looking at them also to figure out what your attorney's fees will be. And then when you're commuting it, and by the way, don't forget regarding commuting off the far end of the award or the side of the award, depending on the percentage of disability that you wind up with. Okay.
Okay, the next case we were talking about was Escobedo. I
think that linked in with the apportionment, correct?
Yeah, just remember that, like the judge said very clearly, the injured worker has the burden of proof the percentage of disability that's caused by the industrial injury. The employer has the burden to prove what percentage was caused by other factors. So stick to your side.
Well, and you know, as a counterpoint to that, often I know that the doctor's opinion on apportionment is bogus, or they've misapplied the law in some way. And even though it's the defendant's burden, I'll go out of my way to evidence that the doctor misunderstands, right? So even though it's the defendant's burden, I'm undermining their efforts to substantiate that opinion on apportionment.
And here's a tip that I'm going to get in so much trouble for saying, but
Uh-oh.
most doctors' apportionment sections are wrong. They have not fulfilled the requirements underneath Escobedo, underneath 4663, 4664. They're just terrible at it, right? Because what are we apportioning to? And they never get that right. Or they don't give us enough information, or they give us a blanket statement. When an apportionment section in a report is like 2 sentences long,
Yep.
probably not right.
Yes.
Just remember that. Sorry. Okay.
Their opinions may not be speculative, right? But nonetheless, I think they often are. And if you press them on, well, how did you get to 10%? They said, well, 20% sounded too high.
Yeah.
I love it. You know, there's a question here. Is it widely accepted that an applicant can have different occupation groups applied to PD ratings for different body parts within one single injury claim?
How would that happen?
I don't know.
No.
What-
Maybe if you have a long CT claim with specific injuries over a long period of time, possibly each claim could, but generally, I don't know how that would happen.
No, but to address that, let's go back to what we were saying in liberal construction to the applicant, right? If you have a scenario like that where there's a long CT claim, right? First of all, if they were doing different occupations at different times during that CT, is it appropriately really just one long CT, or is it multiple CTs? That would be my first question as a judge. Second of all, when you're talking about that, let's say there is one long CT. It is one long CT and you have different body parts. Rate it out with the different occupational group numbers that you have and figure out which one rates highest, because that's the one you're going to argue for.
Okay.
There is a lot of overlap too when it comes to the occupational groups. So like the judge said, don't be afraid to try different scenarios. And again, the applicant is usually entitled to the highest rating.
All right, there's another question here that has to do with one of the things we just went over. So if the apportionment by med legal doc is just wrong, like you stated, one sentence long, et cetera, but it's an AME instead of a QME, would you defer to the AME?
Well, there is cases that talk about relying more on an AME, or why there are cases that talk about you chose an AME for their expertise. So let's try to rely on the AME because everybody's agreeing to it. I'm going to look at that Dolan case. Whoever just put that, I'd love this site.
A good case. Yeah.
Yeah, I want to look at that with different occupational codes for the same injury. I want to look at that. But going back to what you were saying with regards to an AME, yes, there are cases that say that we would like to rely on an AME. Parties rely on them for their expertise. I think it's the Place case was one of them. So just giving deference to an AME, yeah, especially.
Sorry, Your Honor. I think that the judge has the discretion to just throw out an apportionment opinion, even if they're relying on the rest of the report, correct?
Correct.
Okay. And then real quickly, we don't have much time at all, but let's try to tackle briefly Blackledge.
Well, Blackledge is one of the judge's favorite cases, right? Because we can kind of let you not abuse our raters. Right, Blackledge is talking about the issue of when can you really cross-examine a rater and what's appropriate to cross-examine on a rater, and basically just very hard to ever cross-examine our raters, because the issue is when we do a formal rating and we're giving the instructions to the raters, you don't get to go back to the raters and say, well, what about this, or what about that, or why did you do this, or why did you do that? If that's our instructions. So really, when you are looking at how am I going to question the raters, there's the practical side in doing law, and then there's the legal side, like what does the law say and what can we or what we can't we do. So let's talk about the practicality, right? A rating comes out that a judge has given in either their FNA or whatever it is, right? The FNA comes out and this is what the rating is. And now you're saying, no, I want to file a recon. I don't agree with it. And this is because I think the rating is wrong or whatever it may be. Practically speaking, right? If there's a question with regards to a rating that has come out, instead of, well, at least at our board here in San Diego, instead of just coming back and attacking it and saying this is so completely wrong, right? If you have questions, just ask the judges what happened or what it may be, even if you need to file your recon. And don't think that, oh, the threat of a recon is something that any judge cares about. We understand it's your right to do so, and that it is naturally part of our job. None of us get up in arms about a recon. Are they annoying? Yeah, sometimes they're annoying, but it's part of our job, and it's your right to do so. But when it comes to something like that, when you have the questions about the ratings, instead of just jumping down the throat of going, I'm going to go after the rater did this wrong or whatever it may be, and Blackledge says you can't really do that anyway, you might want to just approach and ask, can we discuss this, or what happened, or these are the questions that we have about the ratings. But Blackledge, really the only reason why we brought it up is because it's really this protective case that we have with going after the raters, and what can you question the raters about, what can't you question the raters about, and most of it usually has to do with the rating instructions that the judge gave, and that's what you're not necessarily the rating itself. Andrew, do you have anything else to comment on that?
Yeah, real quick. Blackledge also has a great footnote about instructing the doctors as to what the law is, which I think speaks to what we're talking about today, that in order to get an accurate permanent disability, you need to inform the doctors about what the law says or doesn't say.
Yeah. All right. We got one last question here for Brent, and it came in specifically for Brent. When is impairment, wrist, other, shoulder, other, etc. used?
Well, basically, there's a couple of other impairments used for the upper extremities. It's basically used when, like we said, there are things that are not covered in the guides. It's a very, very old text. Things like fibromyalgia. There's a lot of different types of impairments, diseases, surgeries. There's a lot of different types of things that are not covered in there. And a lot of times examiners will use other in that case. There's a lot, there's many to name, but it's just when something's not illicitly covered in the guides.
All right. Well, I want to first of all thank our panelists for taking the time out of your day in order to come on here and give all this information. Thank you to everybody who attended. Hopefully you got something out of this that can help your practice. We are trying to do one of these every quarter, so look out for another one coming to you soon. And again, you can find this and other webinars on our Gemini YouTube channel that are free to go ahead and watch at any time. So thank you, everybody. And with that, I'm going to go ahead and conclude the webinar. Thank you.
Thank you.
Thanks.
All right.
Take care,
Bye-bye,
everybody.
all.